All right, good evening, everybody. You'd think that after 2 years of Zoom, it would be more straightforward to do this, but there's always little glitches. Thanks so much for your patience. My name is Mcsorley. I'm the National Coordinator with the International Civil Liberties Monitoring Group. And thanks so much for being here tonight. Just as we get— Good evening, everybody. You'd think that after 2 years of Zoom, it would hold on, sorry, I just have one problem.
The technology is not making this conversation easy for us.
Sorry, I'm very sorry, everybody. Okay, so
it's all sorted.
As many of you will know at this point, we're also live streaming on YouTube. That's what you just heard in the background, and I've got it under control now. And just so you know, we're also recording tonight's event. So if you don't want your image, it's not likely that you'll pop up. But if you want to make sure that your image is not recorded, you can turn off your camera. And you won't be shown either on the recording or on YouTube. So again, thanks so much for being here tonight. We're really grateful to have such a wonderful group of speakers joining us. My name is Mcsorley, and I'm the National Coordinator of the International Civil Liberties Monitoring Group. We're a national coalition of 45 organizations that since 2002 have been working together to defend and protect civil liberties and human rights in Canada from the impacts of anti-terrorism and national security laws. Before going further, I'd like to acknowledge that the land from which I'm joining you tonight is the unceded territory of the Anishinaabe Algonquin people. We pay respect to the Anishinaabe Algonquin people, who are the original guardians of this land, and we thank them for their stewardship of this land. We acknowledge their longstanding relationship with this territory, which remains unceded. We pay respect to all Indigenous people in this region from all across these lands who call this land home. And we acknowledge the traditional knowledge keepers, both young and old. We honor their courageous leaders, past, present, and future, and we welcome the resistance and resurgence of Indigenous peoples as part of the decolonizing process. I'm really excited to be co-hosting tonight's event with Aziza Kanji from the Noor Cultural Center. Aziza will have a few words to say very soon. But just as a very brief introductory note, tonight's conversation is a complicated one. The horrific attack on the Quebec City Mosque sent reverberations across our country. It demonstrated in terrible fashion the Islamophobic and hateful violence that so many had warned about, and that our governing institutions ignored and honestly continue to ignore. We join calls for justice for those killed, injured, and for their communities, and for more to be done to fight Islamophobia. However, it also raised questions of what justice looks like. It raised questions about what the fight against violent white supremacists should look like. In our organization's work to counter the way that anti-terrorism laws have attacked and undermined civil liberties for the past 20 years, including how they have been used to target Muslims, Indigenous people, and others, the conversations have been difficult. In our current moment, when we see the state using anti-racism to expand problematic tools, including terrorist entities lists, the no-fly list, and other terrorism offenses, this conversation tonight is a vital one for us to be having. I'm very grateful for you to be here with us and for our really esteemed speakers to have joined us tonight. I'll pass it over to Aziza now, and then we'll get back to introducing our speakers.
Thank you, Tim. And I'm Aziza Kanji, and I'm the Director of Programming at Noor Cultural Center, a social justice center based on Islamic principles in Toronto. Toronto being the land, the territory of the Haudenosaunee, the Anishinaabe, the Huron-Wendat, and Mississauga peoples. These land acknowledgements are not simply a perfunctory performance that we recite at the beginning of events and then move on from, but rather they are a reminder to us that when we are having conversations about racism in Canada, whether it be the racism of an Alexandre Bissonnette or the racism of the prisons and policing system, the entire context for that conversation is the ongoing violent settler colonial dispossession of Indigenous peoples from their lands. Tonight, we also remember and mourn and hold in our loving prayers all those who were killed, injured, and bereaved in the Quebec mosque shooting, in the London attack, in the attack on the IMO mosque. 3 fatal targeted assaults on Muslim life in the last 5 years. We also remember and hold in our love and in our solidarity those who have been killed by the prison and policing system itself, including Abdurrahman Abdi, Ijaz Chaudhry, Suleiman Fakiri, and Abdurrahman Abanasawi, those who have been killed and tortured by the very prison and policing system that is represented as the solution to white supremacist violence, rather than also being part of the problem. In a discourse which often traps us between the violence of white supremacists like Alexandra Bissonnette and the violence of a racist settler colonial state, we are so grateful to be with all of you here today to think collectively and carefully about whether a white supremacist policing and prison system can provide a solution for the violence of white supremacists like Alexandra Bissonnette, to consider whether the Bissonnette decision is simply another instance of lenience against white supremacists, or whether and how it can also be used to advance anti-racist and anti-colonial struggles against prison violence and brutality. And finally, to also remember, canvass, and imagine ways of achieving justice and accountability for white supremacist violence lying beyond the horizons of the settler colonial state. So we are so grateful for all of your presence here tonight and the presence of our esteemed speakers, who we will introduce very briefly. Full bios are available for them on the websites of Noor Cultural Center and ICLMG. So we will just be giving very short introductions to our speakers, and then we will be doing 2 rounds of questions with them, and then we will be taking all of your questions from the floor. And so please, throughout this discussion, please continue to put your questions into the Zoom chat, as well as for those who are watching on YouTube, put your questions in the chat there, and we will get them to the panelists. And so Tim, if you will do the first bios of our speakers tonight.
Thanks, Aziza. First, I'd like to introduce Elle Jones, who's a spoken word poet, journalist, and community activist who has been involved in the prison justice and abolition movement for many years. She is currently also an assistant professor in political and Canadian studies at Mount St. Vincent University. Thanks so much for being here tonight with us, Elle. I'd also like to introduce Atia Hussain, who's assistant professor at the Department of Law and Legal Studies at the University of Carleton, or sorry, at Carleton University. Thanks so much for being here with us tonight, Atia.
And Kent Roach is professor at University of Toronto's Faculty of Law, and he taught me everything that I know, and also much that I'm sure I have forgotten about national security law, criminal law, and remedies. He is the expert in these areas, and so we are so delighted that you are here with us tonight, even to discuss such a harrowing topic. And Yavar Hamid, finally, is a human rights lawyer at Hamid Law, and he really is so familiar with the intimacies and the violence of national security law in Canada from the inside out. And so we are really privileged also to have him here with us tonight for this conversation. And so we'll begin with our rounds of questions for the panelists. And we'll start with you, Kent. Sorry, it's so hard for me not to call you Professor Roach and just to refer to you as Kent. But so Kent, we'll start with, if you could perhaps explain the substance of the Bissonnette decision. Understandably, for Muslim communities and other communities, I think this decision has caused a lot of grief, a lot of pain, and a lot of upset of coming from a court system that continues to delegitimize and marginalize and minimize Islamophobia. But I think there's also been a certain amount of unclarity about what the decision actually says. And so can you please explain to us what the decision was and what the basis for it is, and also the scope of its holding?
Yeah, well, thank you very much, and thank you for the generous introduction. So basically, what the Supreme Court has done is strike down as cruel and unusual punishment under Section 12 of the Charter the ability that the Harper government put in for a judge to add 25 years ineligibility for parole for each victim in a multiple murder. So the Harper government saw this as a kind of discount, was against a sentencing discount for multiple murders, but as they often did, it was a kind of crude sort of way to achieve this end. And the trial judge in the case, I'm not going to repeat the person's name because he doesn't really deserve to be recognized. The trial judge declared that he was ineligible for parole for 40 years. Then he appealed to the Quebec Court of Appeal, and like the Supreme Court of Canada, they struck down this provision, which effectively means that he and anyone else sentenced for multiple murders will be subject to the same 25 years ineligibility for parole, in addition to their life sentence that first-degree murderers receive. And first-degree murder is the more serious form of murder. Now, the court in this case, and I followed the Section 12 jurisprudence really since I was a grad student, and the court here did something that struck me by surprise, is that they said that it was kind of per se cruel and unusual and degrading to human dignity to impose a sentence on a person that gave them no realistic prospect of rehabilitation. So the idea here is if a person is ineligible for 50 or 75 years or 100 years, then they're essentially going to die in prison. And I actually, and this is something we can get into, I don't really have any particular problem with that proposition. People should know I represented the Canadian Civil Liberties Association unsuccessfully in the Latimer case, where we argued that the mandatory life imprisonment, even for second-degree murder, should be struck down. But what I find troubling in this decision is the court did not use it as an opportunity to revisit Latimer, or indeed an earlier decision called Luxton, which upheld 25 years ineligibility for parole. So the court, on the one hand, seems to express some sympathy for someone who is relatively young and is convicted of first-degree murder. They don't want that person to essentially have no prospect for rehabilitation. But the court goes out of its way to say Luxton is still good law, even though it notes that 25 years ineligibility for parole is quite a harsh sentence. And at the time of Luxton, there was a possibility for a person subject to that 25 years ineligibility for parole to go before a jury after 15 years and to convince the jury that they had rehabilitated themselves and they should at least be able to apply for parole. Parole is not automatic. It's a decision made by the parole board. So to me, this is a bit of an outlier because the court has been deferential to our rather harsh life imprisonment sentences for murder, except in this case. The court has been fairly active in striking down mandatory 7-year sentences for importing narcotics, mandatory 3 or 4 year sentences for firearms. So the court has been active, but not active with respect to the murder sentences. And I think I'll leave it at that so my panelists can say things, but I guess inveterate law reformer that I am, I do have some ideas about how something perhaps good can come out of this decision, but I'll leave that to the second round of questions. So thank you very much.
Thanks so much, Professor Roach. Kent. I'm doing the same thing. Next, we'll go to Elle Jones for the next question. I'll just put you on the spotlight, Elle. Elle, there's been much discussion about whether the imposition of consecutive life sentences is important in order to, quote unquote, fit the severity of the crime. We're wondering if you see justice as being synonymous with longer prison sentences, and if not, what are some visions of anti-racist justice and accountability being developed beyond the carceral state?
Thank you. Yeah, to start with, as Kent just laid out, the issue isn't so much this sentence, but this sentence in relation to other sentences. And of course, people are rightfully observing how harsh sentencing seems to be reserved for Indigenous, Black, and Muslim people, and then suddenly this compassion comes in when it's a white supremacist. However, we should not therefore be led to arguing for harsher sentencing regimes because they only rebound on Black, Indigenous, and racialized people, and not exactly, as this case shows, on the people that we imagine these sentences are so-called for. And this shouldn't, of course, be surprising because I don't think it should be a mystery to any of us that the court and policing system are white supremacist at their root in their conception and in their execution. So the idea of relying on courts or policing to be any kind of instrument of justice for us, I think, misunderstands what a court is. Now, that doesn't mean that there aren't lawyers or judges or decisions that are compassionate, that are human-based, that push things forward. I don't want to take a totalist view and say, nothing that ever happens in a court can ever, remedy a human right or something like that. But overall, the notion of turning to these systems to find justice, especially for something like racism, I think that's a non-starter. But before I go any further, I do want to acknowledge, of course, that, the immense pain of communities, the immense terror that communities are feeling. So I wouldn't want my comments to be taken as some kind of intellectual critique of, oh, well, if people ask for these sentences, here's all the mistakes they're making in thought, when people have died and people are dying and more people will die. And that is a very real and very painful thing. And we always have to hold that at the center. But what I want to say here is that it isn't a coincidence that we saw an expansion of Islamophobia at the same time as we saw an expansion of the carceral regime, which is under Harper, right? So Harper was both our most prison-intensive prime minister and our most Islamophobic prime minister. So the idea that prisons are somehow this remedy for fighting Islamophobia shows that these things actually aren't separate and they go hand in hand. So under Harper, we had, as we've had under all governments, a massive expansion of the punishment regime, including lack of access to parole, including lengthening of sentences, including even foolishness like the kind of programs that could be offered in a prison, or cutting what was on the menus just in case anybody got a birthday cake in prison or something. So implications that Trudeau promised that he would change when he came into office and has done very little to undo, and now getting, slight changes to mandatory minimums for things like very small drug possession, while they're at the same time promising to increase penalties for things like guns, drugs, and gangs, which we know are coded as Black. So right now we're being sent a message by our system that, again, white people are not our target, and things that white people might get caught up in, such as drug possession, we're going to make sure you guys get reform. But the people that always experience the system, Black people, we're going to actually intensify our policing. And this has continued, and this expanding prison regime, as Deborah Parks observes, continues under governments of all political stripes across Canada. So why don't I advocate then the expansion of sentencing? I want to say with Harper too, let's not forget that Harper as well, not only did he propose the barbaric tip line, he refused healthcare to refugee claimants, talking about old stock Canadians deserve these. We saw the privacy bills, a huge bunch of civil rights violations, the no-fly list. All of these things happened under Harper, right? So this idea that the government somehow is hands-off with Islamophobia, and then what needs to happen is we need to take somebody like Bissonnette and give him extremely harsh sentencing, and this is what will deter Islamophobia or white supremacy, is absurd when the same governments are repeatedly refusing bills against Islamophobia, claiming, for example, that it stifles free speech. We have Quebec with its Islamophobic laws that nobody in the election could even bring themselves to condemn in the federal election because they wanted Quebec votes. So, let's recognize that Islamophobia is structural and within our government has repeatedly been enforced, perpetuated, and expanded in our governments. So the idea that this one prison sentence is somehow going to be the solution, or that the police are going to be the solution, when we have legislative Islamophobia, I think, again, calls for some critique. The reason, obviously, why I don't support an expansion of the punishment regime, as I said, is because we may think and believe that what we really need is these sentences for white supremacists. But as we know, what actually happens is Indigenous people that get labeled dangerous offenders. It's Black people that largely get threatened with or given indeterminate sentences. And when we look in Canada, for example, it's Indigenous women that are entirely dangerous offenders, and none of them even committed a violent crime before they went to jail, right? Indigenous men make up 30% of dangerous offenders. And this is not serial killers. This is sometimes somebody that like stabs somebody and then has another stabbing, or is in prison and gets an offense in prison and then gets put on the dangerous offender list. So we know that indeterminate sentences are so largely directed towards the Black and Indigenous community. We don't even keep stats on Black people in indeterminate sentences, by the way. So when we think about expanding punishment in this way that will occasionally catch these white radicals, the same white radicals propped up by the government, the same white radicals that are allowed to operate online like unfettered, the same white radicals that can be caught with guns at the border crossing and occupy Ottawa for 3 weeks, you know, all of this that can happen. And then the idea that this one sentence is going to do something, I think, misses what it means to live in a white settler colonial racist white supremacist regime that has created these conditions, continues these conditions through our policing of borders, deportations, our Islamophobic rhetoric, our racist rhetoric, and then, you know, says, oh, but don't worry, the prison system will solve it. And the last thing, I know we don't have much time, is the reason why particularly Black, Indigenous, and Muslim people should be skeptical of this is because we have made our demands for justice. We have understood and recognized that funding the police and punishment and the prison regime at billions of dollars a year in Canada. You know, police forces themselves in my city, Mi'kmaq territory, Jabuktuk, Halifax. We have like $100 million police budget, which is in all cities, dwarfs, you know, all the other services combined. We spend another $72 million on the provincial correction system. Then there's all the billions of dollars federally, you know, and we have said as Black people, as Indigenous people, as racialized people, we want you to stop. We want you to lose your weapons. We want to detask you. We want you to stop showing up on calls. We want to defund the police. We don't want more punishment. We want social programs. And so this sudden push on hate crimes, and suddenly they take hate crimes so seriously, has nothing ago, they were forced to apologize in Toronto for their racist strip searches and racist use of force incidents. And like, you know, it has nothing to do with that. They continue all over the place to racially profile us, harm us, brutalize us, and murder us. It has to do with them using this rhetoric to try and maintain their police funding, right? So at the very moment that Black people are like, no, we just don't want you to have money. How about that? How about you just lose your budget? They come in and say, well, no, don't you need us? We fight hate crimes. We're going to have hate crime units. So this is clearly a rhetorical move to actually try and outflank us using our own rhetoric of anti-racism, not to do all the things we've asked for that actually fight racism to make social changes, but to actually continue funding the police who continue to be racist. So I think it's very important that we resist this rhetoric around hate crimes, this rhetoric around the idea that the police will be the force that solves that, and that prisons will be the force that solves that, and that we remember that we have always known what we need to do to organize against white supremacy, to actually de-radicalize people. I hate that term, but you know, they always use it for Muslim people and then won't use it for white people. You know, so I just think that one of the difficulties in our communities is because we are in pain, because nothing is being done to solve racism, because we see these crimes and we want to turn to this solution that seems obvious or perhaps simple or waiting for us, right? Why don't we have these penalties? But we know that when they in fact have hate crime units, they don't prosecute white supremacists, they prosecute anti-capitalists, they prosecute people that say ACAB, they prosecute people for having the anarchy sign, they prosecute property damage against corporations, they prosecute hate crimes against the so-called police and claim that's a category. You know, so these are all is what will happen if we actually accede to the idea that we want to expand the punishment regime further. I'll stop talking. I know we have another round. Sorry, I went too long. Thank you.
Thank you, Elle, for speaking so powerfully to the racial disparities that absolutely ensure that any further harshening of punishment is guaranteed to only rebound further back upon those who continue to experience the harshest edges of the carceral regime. And we'll get later to the question of whether it's helpful or harmful to try and then apply the discourse of radicalization and terrorism to white supremacists themselves. But now I want to turn to Yaver. Speaking of these deeply entrenched disparities, something that really struck me when reading the Bissonnette decision was the emphasis that was placed on the central importance of rehabilitation for a shooter like Alexandra Bissonnette, when we know in the context of Muslims being sentenced for quote unquote terrorism, courts have explicitly said that the purpose is not rehabilitation, that it's to denounce and deter and inflict harshest punishments possible. And so can you talk a bit about, specifically in the context of quote unquote terrorism, the type of racial disparities that pervade the logic distinguishing the treatment received by someone like Alexandra Bissonnette from the treatment that Muslims and other racialized and colonized people most targeted under counterterrorism continue to receive?
Thanks for the question, Aziza, and thanks to the organizers, Tim and Anne, as well for putting this together. My career as a human rights lawyer has really been punctuated by September 11th. I started practicing as a human rights lawyer in 2001. And so I'm very conscious of some of the great work that Kent Roach has done, talking about the consequences of September 11th from a legal perspective, and putting into context when we created the Anti-Terrorism Act 20 years ago, the question about the necessity of having that legislation in the first place. So when answering, I'm trying to answer your question, I'm going a bit more broadly. When speaking about a decision, a sentencing decision, which is not a terrorism offense decision, it's important, I think, as you're suggesting, to consider the context within which terrorism offenses and the specter of terrorism is levied against Muslims. And I think that the context, or the missing piece here, is that Muslims and people in the Arab communities for 20 years plus have been, not exclusively, because other racialized communities, the Sikh community as well, have been similarly targeted, but certainly in the last 20 years, there's been an explicit targeting or an implicit targeting of Muslims, such that when we talk about, terrorism offenses, the Anti-Terrorism Act, there is this impact that the community feels viscerally, because it is the case. I've for about over a decade litigated one of the security certificate cases in the federal courts. And one of the things, sort of pivoting a bit from the criminal sentencing process, is that the specter of terrorism and terrorism concerns permeates as well immigration laws, which do not have the built-in safeguards that exist under the criminal justice system. And so I think that there is this pervasive net of suspicion, and certainly in the security certificate context, a sense that one must prove, as the person who's under that suspicion, that one doesn't have, terrorist, aspersions. And so in the case of Mr. Majoub, that has been something that he's been trying to do for 20 years. He still remains under immigration conditions. Now, more specifically, is answering the question about, comparisons of, in the context, knowing that terrorism offenses disproportionately or significantly affect Muslim and Arab communities, there is this, language within criminal sentencing, and I point to, I'm not a criminal sentencing expert, but looking at the Khwaja decision, for example, that was dealt with by the Ontario Court of Appeal and the Supreme Court, the idea of rehabilitation and the fact that the significance of that factor, which is always a factor to consider in sentencing, on the facts of that case, Mr. Khwaja's case, but I think more generally, implicitly within the language of the Ontario Court of Appeal, the sense that someone could espouse terrorism beliefs and that would disqualify them from not necessarily the prospect of being rehabilitated, but just that it wasn't really as significant a factor when it comes to sentencing. And the thing that brings to mind is the analogy in the context of security certificates and in an intersection between criminal law and immigration, where for certain kinds of offenses that are levied against racialized persons, one has to prove the negative. Well, one has to prove that they're worthy of these basic protections, such as rehabilitation, the prospect of rehabilitation, or in the case of people who are not convicted of a crime or only suspected of being affiliated with a terrorist organization, that those individuals, have to prove to the court their worthiness to have safeguards under the law. So I think that is, something that's quite significant within, I think, the language of the court, but also if you look at, I was reading the decision today at paragraph 145 of the decision, the court speaks about the most heinous kinds of offenses that exist. And, of course, they talk about serial murders, and the Bissonnette case was a serial murder. Obviously it was. It's the most serious and despicable kind of crime that can exist. They also talked about serial sexual predators, which I think we can all agree with. And then it talks about terrorism offenses. And so the court thought it important in that context to draw again the specter, while, speaking about the sentencing of this individual who's not being, criminalized or prosecuted for a terrorism offense, that there is this other very serious offense of terrorism out there. And so, when we look at that language, the language from the Khawaja decision, the kinds of things, and perhaps this could be, for subsequent intervention as well, the ways in which racialized people, particularly immigrants and refugees under the security certificate regime, constantly have to reaffirm and affirm their humanity in federal court at periodic detention reviews. It boggles the mind that even not being charged with a criminal offense, the language, the power of this language of terrorism means that you are effectively presumed guilty. And, we see that as well in other regimes, listing regimes, such as under Section 83 of the Criminal Code, listing terrorist entities. I represented Irfan Canada in an attempt to have their name delisted. And I think that, part of the legal infrastructure.
Can you just quickly explain? Irfan Canada was a Canadian charity that was listed for medical donations to Gaza.
And so thanks, Aziza. And so in that context, the listing of this organization or listing of any entity is a secret process. It's an ex parte process where effectively you have a form of judicial review after the fact, but it serves to chill whole communities that fall under this umbrella of suspicion. And so the danger here in the language of terrorism and the implication of these courts' decision is it's far reaching, and it has a chilling effect upon a whole community.
Thanks so much, Yaber, and really appreciate you being here and for the really incisive nature of your comments, all the work that you've done over these past years on these issues. It's really, to have your wealth of knowledge and insight, it really means a lot. And there's a lot of those issues I'm sure we'll come back to later, especially maybe you mentioned the criminalization of Sikhs in Canada, and just recently in Ottawa, there was an incident. Maybe we'll be able to talk about that some more later. I think it would be a good parallel to draw as well. But next, we're going to move on to Atia Hussain. Thank you so much for being here with us tonight, Atia. And we wanted to ask you about a related case that's come up since the Supreme Court's ruling on this sentencing. And following the Supreme Court's ruling just a few weeks later, we learned that Crown prosecutors have commenced terrorism proceedings against Mohammed Moise Omar for his attack on the Dar al-Tawhid Islamic Center in Mississauga. And the prosecutors there have said that this will allow for tougher sentencing. So given that the that Bissonnette was never charged with terrorism. How would you see this development from an anti-racist perspective? And should we consider the increasing tendency to treat hate as a form of extremism and terrorism to be progress? Or is there another approach that we should be, or another way we should be thinking about this?
Thank you for that question, Tim. I think the comparison is really interesting to make, and so that would be a good place to start. Some of the similarities and the differences between the Bissonnette case and the Omar case. So what was similar is that both of their victims were Muslims at a masjid just praying. And what was different is they used different weapons, and there were very different levels of damage. So Bissonnette killed 6 people and seriously injured 5, right? But Omar did not kill anybody, and he did injure several people with bear spray and attempted to with a hatchet. And where this question's coming from, I think, is the debate around the consequences for both of these people. So the debate around Bissonnette, I think the other panelists have already done a great job of laying that out around sentencing. And then the debate around Omar is that he was charged with terrorism, which would enhance his sentencing. And that's been confusing for some, people who are paying attention to this case because the level of damage was so different. So getting more into it at this point, we might, start to consider the role of race, since what we haven't talked about yet is the obvious difference between these two men, that Bissonnette is white and Omar is not. But there isn't something that automatically happens that eases Muslim communities' suffering once authorities recognize that race is a factor, which is what some anti-racist approaches assume. So instead, what I think we need to do is be specific about how race works here. And so we might think that, the issue of race lives in how these people are different from each other, but I think it actually comes up much earlier, and that it has to do with something that both of the cases share. And a concern in both cases is the legitimacy of the criminal justice system and its relationship to the public. So in the Bissonnette case, in the Supreme Court case, that is explicitly stated. So the decision reads, quote, "The imposition of excessive sentences that fulfill no function," because Bissonnette wouldn't live 150 years to serve all of that, "they fulfill no function, does nothing more than bring the administration of justice into disrepute and undermine public confidence in the rationality and fairness of the criminal justice system. A punishment that can never be carried out is contrary to the fundamental values of Canadian society," end quote. So then looking at the Omar case, there is a desire for tougher sentencing to send a message. There's a focus on the community's feelings of safety. And that's what the police chief in the area was talking about. Something along the lines of Islamophobia has no place here. So what you see is that both cases involve sending a message that is protective of the legitimacy of criminal justice and related governance. And this is where I think race comes in, based on a historical understanding of race and criminality. So race became a central part of the justice system and criminal identification in the late 1800s and the early 1900s. So at that time, European race science was emerging, and it was obsessed with establishing a relationship between bodily measurements and criminality, along with morality and civilization. It had this idea of an ideal human. Whatever did not fit the terms of the ideal human could be criminal. So it was a pretty big umbrella of criminality. What we see in these two cases is a runoff from that history 100 years ago, in which the main concern was upholding the legitimacy of an ideal human whose interests are still represented in and by law, criminal justice, police, and other institutions, often as though their interests were all humans' interests and not just some humans' interests. The idea of that ideal human built our contemporary institutions, and it's tweaked and updated for our context now. And one of those newer developments in our context now is, of course, the power of terrorism discourse. So I'll end with your question about terrorism specifically. So like the criminal category in the history that I just laid out, the terrorist category has also been pretty broad, actually. So looking at the US context, which is where my research is, and that, it's also just a major exporter of all things terrorism. The history of terrorism goes back, well, as we know it today, goes back to the 1970s and the Cold War context. And the focus was mostly on the left, anti-war movement, revolutionaries, anti-colonial movements as terrorists. And then you have the 1979 Iranian Revolution, which does a lot to kind of cement this idea that the Muslim is the terrorist. And the Cold War develops in such a way that the US thinks that the Soviet enemy is sort of replaced by the Islamist enemy. And then as you get into the 1990s, you have environmental activists who are increasingly charged and prosecuted as terrorists, as well as white supremacist movements in the US. And then, of course, you have 2001. And since that time, you do still have all of these groups prosecuted as terrorists to some degree or another, with Muslims more likely than most, of course. So this history of terrorism and criminality as really broad categories that anything or anyone that doesn't fit that ideal human can be put into is important for how we approach the issues today. So we still have that system that is built to represent that ideal human's specific interests at the expense of the rest of us. And those interests can be furthered through ideas of criminality, terrorism, free markets, and even anti-hate, if that's a value that that ideal human happens to develop, which would seem like it's all about our interests, but that's not how we're seeing it play out in the Bissonnette or Omar cases.
Thank you so much for that, Atya, those profound comments, but also the deep history that you provided us with in capsule form that lie behind the present. Over and over in this conversation so far, the idea has come up that the racial line in application of criminal law is really about the projection of some people as being inherently, essentially violent and a source of risk. That violence is projected as inherent to people who in fact bear the brunt of social structural violence in Canada and yet are represented as the threat from which the nation or the public needs to be protected from. We've heard more and more recently that the solution to this deep intrinsic inequality is simply to expand the category of terrorism to also encompass white supremacists and others who have benefited from the racial disparity historically. Professor Roach, Kent, you have written both about the absurdities that have been produced in application of quote unquote terrorism law recently, including the way that the application of terrorism law has been used to prevent helping Afghan refugees come to Canada. And you've also written warnings about the dangers of applying counterterrorism measures like terrorist entities listings as a solution to white supremacist violence in Canada. And so can you offer some comments on whether the solution to the inequality in the counterterrorism context is to expand counterterrorism or rather to deconstruct the concept of terrorism itself towards an abolitionist future?
Yeah, thank you for the question. And I may not have been completely consistent in my views. I mean, as has been mentioned, I oppose the creation.
Consistency is just an excuse for being boring and static. So we celebrating consistency here.
Exactly. No, but I opposed the creation of the Anti-Terrorism Act in 2001. I represented unsuccessfully the BC Civil Liberties Association in Kawaja, asking for it to be struck down. So I don't consider myself an enthusiast or a friend of terrorism laws, but I did write an op-ed in the Globe and Mail saying that Bissonnette should have been charged with first-degree murder by way of a terrorist activity. And I did that strategically to point out the discriminatory double standards that many of my panelists, fellow panelists have talked about that associate terrorism with Islam and terrorism with brown people. Whether that is, a smart strategy going forward, I think maybe the verdict is still out. I frankly, as I get older, there's more things I don't know, and I don't know. But I do think it is important to call the state on its discriminatory double standards and to raise the reality that far-right political violence has been far more deadly in Canada. Over 25 people killed by my count, and that may be an undercount, since 2014. So I wouldn't say it's expanding terrorism law. I would say it's applying terrorism law without discriminatory standards while leaving up to perhaps thinkers brighter than me, whether the terrorism, leveling up terrorism to include far-right terrorist laws that we already have and that are not going anywhere, and that have been upheld, rightly or wrongly, I think wrongly, under the Charter. If we're going to have them, I think, what's sauce for the goose is sauce for the gander. But where do I think we should go from Bissonnette? I think what we should do is demand that the government reply to this decision. Just today, the government has introduced a bill responding to the extreme intoxication decision. Why is that a priority and not responding to the Bissonnette decision? And this is obviously up for everyone to your own kind of political strategy. And I think that some on this panel will disagree with me, and I respect where that disagreement will come from. But I can see a move in which there could be an anti-racist response, parliamentary response, that actually gets rid of the mandatory 25 years, and dare I say, even the mandatory 10 years ineligibility of parole, and provides a non-exhaustive list of aggravating and mitigating factors that will give greater discretion in determining what a person's sentence is for murder. I think that would be a good thing. One of my areas is wrongful convictions, and we know that a lot of racialized, Indigenous, and other women plead guilty to manslaughter to avoid a kind of mandatory life imprisonment. And so I think that there is a window for changing the laws and the sentencing of murder. And the Supreme Court of Canada, while upholding Luxton or seemingly not casting doubt on it, something I think was a mistake, recognizes that this is a long period. Also, what I found the most shocking issue is the Supreme Court admits that the average lifespan of people in prison is 60 years old. Think about that. 60 years old. That tells you something very concrete about who is in our prisons and how they are disadvantaged. So I actually see an opening should, and this obviously is not a decision for me to make, but should various communities who have been targeted by white supremacist far-right violence don't want Bissonnette, this decision, to be the last word, to do so in a way that could actually make sentencing for murder a much more open and contextual process. And I think we can learn something from feminist law reforms in terms of that. Will it work out perfectly? Probably not. But I do think that it is something that should be seriously considered, and the government shouldn't be let off the hook. Why does the government reply within a matter of weeks to the extreme intoxication decision, but remains so far silent on this decision, which sends out messages that the multiple victims, the 6 people who died while worshiping, and other the Avzil family in London, that doesn't matter. So I do think that there is a way to count multiple murders, to count, I would say, hate more than terrorism as aggravating offenses. But I would like to see that done in a way that gets away from mandatory minimum sentences and allows us to have a clearer legal, political, and moral debate about the seriousness of particular forms of homicide. So thank you.
Thanks so much, Kent. And that's some really interesting ideas about how, looking at the context of this case, we can't, and I think many of us feel the same way, let the government off the hook as we go forward and make sure that there is follow-up, especially when we're talking about mandatory minimum sentences in other situations, and that this can't just be viewed in isolation. We're going to go now to our second round of questions. So we're going to go back to Elle. And Elle, you spoke about this really powerfully in your first answer. So I think we'd like you to maybe respond a little bit more, and maybe you have some ideas to build on from what some of our other speakers have said so far. But as you said, that we know that even as we're talking about this, the Bissonnette case, that those who face the harshest sentences are not on average young white men, but it's rather Indigenous, Black, and other racialized people who are imprisoned at higher rates, face harsher sentences, and face parole refusal. Do you think that this ruling will really have an impact on those who bear the strongest brunt of the so-called justice system and our criminal system? Or what are other approaches we should be looking at and taking in order to fight back against those?
Yeah, I kind of answered some of this. I will say that it's interesting that this decision opened the door for Justin Bork, who was the person that was convicted of killing 3 police officers in Moncton, and his lawyer said that he's going to appeal. So that'll be interesting to see how the state responds once it's not Muslim people that are at issue, but actual police, right? So I'm interested to see what will happen then when that rhetoric gets expanded. Okay, well, if he said, and his lawyer said, yeah, I agree, rehabilitation. So my client should have access to that as well. But of course, that was dead cops, which is an entirely different matter, right? So I'll be interested to see how that decision plays out. I did want to, I guess, follow up that notion of rehabilitation and the deep hypocrisy of the courts in suggesting that the purpose of the system is rehabilitation when, what rehabilitation exists in prison, right? So as has been pointed out, life sentences in Canada have been steadily expanding. They used to be about 7 to 10 years. They're up to about 18. The parole board, which does not release its decisions and doesn't provide us publicly with race-based data, for example, so it's very hard to know what they're even judging. Black people anecdotally say, you don't even get parole in the East. People go out to BC to get parole because it's well known in the East that Black people don't get parole, particularly on the first try. I know somebody that's 37 years into a 25-year sentence who did kill a cop, and they just find ways to, every time he gets close to parole, they sabotage him, move him back to a max, just find ways, because of course the correctional officers also believe they're cops. So, this idea that there's rehabilitation within a system that demands things like escorted absences, then refuse them, that doesn't provide mental health, that, you can maintain and develop a drug addiction in jail. There's certainly, no real rehabilitation. They commit psychological acts of abuse, in terms of any of the counseling you get is done towards your parole. And people have talked about how useless it is and how much it traumatizes them and prevents them from getting actual help. The fact that people who need methadone are stripped naked and forced to wait in rooms after their methadone. And this is what we're calling rehabilitation. So, the idea that the court has the audacity to talk about this principle of rehabilitation and then double down on it because it's white people that are seen as rehabilitatable, while Black men with guns, of course, are never imagined as so. And then they don't provide anything, whether in prison or community, to do that, I think should outrage us. Somebody asked in the questions, what is the point of a prison sentence? And yes, like if you can't get it done in 10 years, what are you getting done in 25, or what are you getting done in 50 when it comes to rehabilitation? Like, one would think that there would be like at least a 5-year plan. And in fact, those on longer sentences don't even have access to the programs because they go by who's getting out first. So lifers are actually way down the list for the stuff that they demand, because they're like, well, you're going to be here forever, and this person that's going to be in for 2 years needs to take the program. So in fact, we don't actually offer rehabilitation in Canadian prisons, if anybody thought that we did. Second of all, prisons are hotbeds of white supremacy themselves. So the notion that a prison is a place where someone will rehabilitate from white supremacy is laughable, given how much that prisons actually actively police racial content to prevent people from actually like gaining any racial consciousness. I've had copies of Malcolm X blocked. I've had, I've sent in political material about Palestine and had that sent back as contraband. I can't even tell you the amount of like Black conscious things I've got sent out of the jail that I've been put on lists for sending in. I've been blocked for numbers for sending in. So, they have literally no interest in anybody learning anything. They completely police those who revert to Islam or those who are Muslim inside. And there's been leaks of correctional guard groups talking about Muslims in the shoe and stuff, and like how dangerous Muslims are. I once sat in a visiting room at Spring Hill and listened to a family have an entire Islamophobic conversation about hijab and stuff. And when I went and complained to the guards, like, we shouldn't have to listen to this while in the living room, they told me I could leave. So, I mean, we've had deaths in prison. Renouf used to be an extreme hotbed of white supremacy in prisons across Canada. It was known for that. And the guards turned their backs while a Black man got stabbed to death with a 12-inch knife by white supremacists. And then they transferred in a bunch of white supremacists on purpose to try and break the African Nova Scotian community within that prison. So let's also recognize that guards are often vectors of white supremacy in prison. Prisons feed white supremacy. And those who actually try to organize against it cross racial lines through labor work, through prison strikes, or through discovering their own religion, spirituality, or racial background are actively oppressed. And this includes Indigenous people, despite our pretense to have Indigenous culture stuff in prison. Indigenous man I know who's challenging them for Indigenous foods has been retaliated upon for months, transferred, put into, the so-called not solitary confinement, which is solitary confinement, blocked from his phones because he's demanding Indigenous food options. So let us also point that out, I suppose. Do I have time to say any more about prisons? I think we have to, let's talk CBSA while we're at it. Sorry. Let's also talk about, I guess I'm just doing all my critiques, because we can't remove from the criminal system and from the discussion of Islamophobia, and Yaver talked a bit about this, our immigration and deportation system that largely targets Black people and Muslim people. We have a CBSA police force with no oversight in Canada. Literally, there is no oversight, either how they operate in foreign ports or how they operate inside immigration detention. People die. We have children in indefinite detention, over 100 children in detention in this country. These are things that we need to think about and pay attention to if we want to talk about the prison system, combating white supremacy, racism, or punishment regimes, and not, this sort of idea that, again, that they can sort of pick out a case. And I don't disagree with Kent Roach in terms of, again, it's difficult because, yes, like we know that Indigenous people have had these sentences applied to them. I know many Black people have been threatened with things like 40 years and settled for 30. They're like, we'll give you 40, we'll give you indefinite, or you can take 40, and they've taken 40. So we know this is happening over and over again. And yes, so it is an outrage to people that the one time they find some kind of compassion around an outrageous sentence is for a white terrorist who murdered, Muslim worshipers. And it's no surprise to any of us that that's where their empathy rides, right? But again, I just say that it is a mistake of abolition in these moments. These are the hardest moments. It's not the person who stole baby formula from Walmart. It's not the woman who's pregnant. Those are easy things to advocate for. Yes, it means that when it is the killers of Muslim people, and yes, the traffickers of Black women, and yes, the murderers of Black people, and yes, the killer cops who murder our community, we have to think ethically around what our principle on prison is then. And that is not easy. Abolition does not call us to make simple or unnuanced or non-complex decisions. It is not the simple political discourse of people are bad and bad people go to prison that often is comforting to us. It requires us to go to a lot of discomfort in ourselves around what it means to advocate for the person who killed an Indigenous woman and what it means to advocate for the person that has killed and trafficked Black women. But the point of abolition is to recognize that if we cannot extend our conception of rights to those people, including to the Bissonettes, then we cannot expect those rights to be advocated for when it's the innocent, wrongfully convicted Black man, when it's the Black woman who has been victimized by men, when it's the Indigenous woman who's a victim of sexual assault. So it is not an easy thing. I have never claimed that an abolitionist principle is simple. I have never claimed that it doesn't cause us pain. I have never claimed that it is not complex. But it is in these moments that we have to, this is when it matters. Not when it's easy, not when it's the wrongfully convicted person. It's now when we say Bissonnette is a horror. Bissonnette committed a terrible act, and he signaled for a long time before he did it that he was going to do it too. He was online harassing people. He was sexist. All the red flags were there, and we did nothing about them. But if we do not now say, and we still have to think about what a life sentence means, and we still have to think about what it would mean to actually heal people, and what it would mean to actually remove people from prison and actually transform things and actually address violence and crime, then it has to be for him too. And that's not an easy path, but we are talking about restorative justice. We are talking about transformative justice in our communities. We're trying to talk about intervening in violence before it happens, what it means to actually educate people about violence, what it means to actually stop these things. And that is harder work than just pointing to the courts and saying, you take it. It's harder work because it requires it to rest in us. I am talking too long. Sorry, I was like, I'll go short this time. And then the person's on screen for 10 hours. Okay, next person.
Thank you. Oh, no, and your 10 hours feel like 10 seconds. Thank you for that, and for demolishing the myth that prisons have anything to do with rehabilitation and can serve as a solution to the very white supremacism that they are built on and continue to incubate. You talked about how important it is that for us as abolitionists, we are consistent in our application of abolitionist principles, even when it's hard, even when it's us who are being murdered and killed. And Yavor, I want to ask you, how do we ensure that protection for the rights of someone like an Alexandra Bissonnette or a Nathaniel Veltman, how do we ensure that protection translates into protection for Black people, Indigenous people, Muslim people who bear the brunt of prison violence? When we talk about consecutive sentencing and terrorism, for example, we know that Muslims convicted of terrorism have received extremely draconian long sentences based on consecutive sentencing principle, having been charged with overlapping offenses, even in cases where no violence has been committed at all. And that unlike the white supremacists who are sometimes charged with terrorism now, their criminalization is not for acts of violence that have already been committed, but is preemptive based on the danger or the threat or their supposed planning for acts of violence, usually instigated in most cases by state informants themselves. And so when we're talking about equalization in the prison system, is the solution then, we've discussed this before, but your thoughts on whether the solution would be to apply terrorism to something like Bissonnette, or do we work to dismantle the very system of terrorism and counterterrorism itself? And what kind of work would we need to do in order to bring our abolitionist struggles to those points?
Thank you, Aziza. Your questions, as always, are very insightful. I want to go back to a point that Kent mentioned, I guess, just in terms of some of his somewhat contradictory views in terms of the different ways in which he's exposed, the double standards and the racism within the Canadian state. And, also similar to what Elle says, to be able to translate, I guess, racial justice and, the problems, the difficult problems we see in the sentencing of Bissonnette to justice for racialized people who are being charged under terrorism law, it requires certain kinds of extrapolations. As I mentioned in my earlier comment, we're not talking about a terrorism offense for Bissonnette, but But if we were, or if the specter of terrorism was brought to bear on Bissonnette, would that solve the problem? My view on that is kind of the twofold. That I see the logic in Kent sort of exposing the double standard of the state, and I think that that's an important discussion to enter into. But I'm very mindful of any kinds of expansions of laws that, for me as a human rights lawyer and a person who's dealt with in various civil and administrative ways the implications of terrorism law, every time we double down, we validate, we expand, the purview and take away these kinds of either the disparity in terms of application of what is already an unfair law, we make it more digestible to the population at large. And I think that within racialized communities themselves, like when violence is perpetrated against that community, I think it is, as Elle mentioned, it's a very challenging decision to say that we need to push back, because we both need to consider, the seriousness of that violence, but also if we use these blunt and unfair instruments of the state, will it have harmful consequences to others in the community? So I talked before about the Irfan Canada case, something which is inherent to terrorism procedures, certainly in the quasi-criminal realm, as well as in the criminal realm to some degree. There's secrecy. There's secrecy in terms of the information on which someone's being detained based on secret information. There is state-to-state information that is constantly being exchanged, which leading up to charges of terrorism might unfairly and inappropriately, cast a shadow upon, persons within the community simply because they are frequenting a mosque. And for the last, 2 decades, this has been a reality of the Muslim community, that there are informants within the community, that there are CSIS investigators who frequent communities, who speak with imams, by basically indicating to the state by saying that terrorism prosecutions and the use of terrorism tools is the right way to go. By implication, I'm not saying this is directly what's happening, but by implication, those very tools, which can involve, harmful surveillance practices, which can involve putting communities under scrutiny, which can involve, in one case that I represented individuals, it can involve searches of their home, it can involve surveillance, wiretaps, it can involve, as it did in the Irfan Canada case, putting the community under the specter of the watchful eye of the state, because once charitable entity is now considered to be a terrorist entity. And so, the entire community will disassociate itself from that organization. And so, we have to ask the question that, is the solution, making these laws more procedurally fair, making them more inclusive for everyone, to have, everyone sort of prosecuted under the same law? Or should we push back? And I think that we can do both. And I'm going to sort of end with this last anecdote, which is not really an answer, but it's I guess it's instructive of where communities are at. And I could say that in about more than a decade working on security certificate issues, there was a fundamental question that was asked in the early 2000s, whether the entire regime should be abolished and scrapped, or whether we should bring in something called a special advocate that could go into secret ex parte proceedings and advocate on behalf of the detained individual. So these are they're immigration hearings that involve terrorist information that may be gleaned from all sorts of sources. And the community movements were for abolition. They were for abolishing security certificate, and they still are today. And I think that they're the importance of having the articulation of that movement of abolition is so important, because if we can't imagine a world where these procedures don't exist, or we question that underlying logic, if we just lose that ability to creatively think about these things, then I think we resign ourselves to the tyranny of these systems themselves. And so I think that there's so much to be said about the power of movements and organizing that can inform sometimes these rather narrow legal debates, where, as legal practitioners and advocates, we're bound by the laws as they exist, but it doesn't mean that a social mobilization against these same laws is inappropriate. I think that it has to be done, and I think that judicially and legally we need to think about these things, because just as Kent mentioned, others mentioned before, embedded within this lofty and laudable decision in Bissonnette is also things that are very insidious to the rights of prisoners. And I think that when you give the state sort of the purview to use language and appropriate, I guess, the language of human rights, they can do it in perverse ways, and communities will suffer because of it.
Tim is going to ask the last question from us to Attia, but I just want to give a reminder to everyone to put in any questions you have for the panelists, either in the Zoom chat or for those who are watching on YouTube. In the YouTube chat, you've been sending a lot of love to the panelists, which is amazing, but please do also put in any questions that you have from them, and we'll go to.
Thanks so much, Aziza, and thanks again, Yaver, and for really reminding us of that long struggle against security certificates and how it brings up those questions of abolition versus reform, and how some, both work hand in tandem, but that we need to keep that imagination going, that memory going, and the perseverance to say that, no, these are things that don't need to exist and that can be abolished. And that is actually a really great lead-in, I think, to our last question with Attia. And Attia, you wrote an article in 2020 that I think was very prescient of the conversation that we're having tonight, called Terror and Abolition. And a lot of people tonight have spoken about, how we can't separate the fight for abolition and the fight against the criminal justice system and its racism and problems with it at large from how we view problems in anti-terrorism laws and anti-terrorist policing. And I was wondering if you could speak some more about how to look at those two together, because often, and even in the work that we do, it's often viewed in the work we do at ICMG on counter, the problems of counterterrorism laws, it's viewed as separate, that somehow CSIS as an intelligence agency, doesn't fit into the same conversation of defunding police or abolishing the RCMP or addressing problems in the criminal system. And so, yeah, if you have any final thoughts and comments on what other people have said, that would be great. And then, yeah, we'll go to questions from the audience after that.
Yeah, definitely. So thanks for that question. So that article, and I think also just a lot of our kind of contemporary, call it left, call it activist, whatever kind of discourse, I think it does increasingly kind of recognize some of the connections between these movements. So instead of giving a kind of laundry list of what those connections are, which I can do later if anybody is interested, I was thinking about approaching this question from a bit of a different angle. Like you said, we have, from the context of the US that I study, the way that we kind of think about things is that you've got the war on terror on one end, and that's a Muslim problem. And that then you have the abolition movement and you have prisons, and that is a Black problem. So Muslim corresponds to counterterrorism and Black corresponds to prisons. And what I think is that this neat kind of racial allocation is backed by a politics of innocence that some in the abolitionist movement critique. And I think their critique is really useful here for considering what these struggles aim to do and how they relate to each other. So that common abolitionist critique against innocence, what is it? It holds that legal guilt has a strong relationship to poverty and other kinds of oppression. So legal guilt or innocence is not a useful guide for who deserves to be free of the carceral system. And I know Elle has spoke to this earlier for sure. The inability to pay fees, fines, tickets, that's just, one set of obviously financial offenses that accumulate into multiple interactions with law enforcement. Further, the selection of an innocent subject is a logic of the carceral system itself, that the innocent deserve to go free and not anybody else. So what does this mean for an entire political struggle? Because that's what the question is about, right? We're not only talking about law, we're not only talking about courts, we're talking about an entire struggle. So what it means is that the logic of innocence, if it's retained, means that movements are compelled to find some other kind of way of deeming their people innocent, as opposed to abandoning that kind of politics altogether and working toward a bigger task, which is to produce a new political subjectivity. So what does that mean, and what would it look like? A new political subjectivity wouldn't rely on the criminal justice system and its institutions, their constructs of guilt or innocence. It wouldn't rely on neat racial representations of Black people being the only targets of prisons and Brown people being the only targets of anti-terrorism. What it would do is it would make it possible to rethink the grounds of solidarity across infinite kinds of difference and not require a reduction to these sort of Western biological notions of racial similarity for thinking about who shares a struggle and who doesn't share a struggle. So the question for anti-Islamophobia work, to me, is not about whether or not it can relate to a movement that is so fundamentally different from it, the abolitionist movement. I don't think that's it. Instead, I think it's about how the anti-Islamophobia work can work toward developing that alternative political subjectivity. It would then have really moved the needle on the bigger project that the abolitionist movement is working toward. So that would be the definition of having a shared struggle, a shared goal. So a bit of a different approach there, but something to think about, law and courts in a broader context of struggle.
Thank you for that, Atia, and for so helpfully deconstructing so many of the categories that are often used reflectively as the terms through which we understand our struggle, whether they're racial categories, whether they're categories of different types of violence, when these are the very categories that have been developed under colonial modernity and by the state to organize its violence in the first place. And so the struggle is really deeper than simply deconstructing systems of violence, but really starting with that deep work of interrogating the way that we understand the way violence is organized in the first place. So thank you so much for that, Atia. We're nearing the end of our time. So if no one has any other questions, perhaps we'll just ask the panelists if any of you have anything that you would like to respond to what you've heard. Oh, Kent?
No, I just wanted to thank you for bringing this together. These are obviously very difficult questions, and I've learned a lot from the panelists' questions, and I thank you for organizing this.
Thank you so much, Kent. I know it was always sort of a running joke / lament in law school that the courts never listen to what you've said or what you've advocated for, and how much better the world would be if they did. And I think so much of this discussion has really been about reminding us that it's not that other futures and other visions for the world have not been lived in the past and realized and aren't being imagined right now. It's not that those don't exist, it's that it's been a choice not to implement them, but that other presents and other futures have been possible. Asad, you have a question?
Yes, I do. It's definitely not a comment, and it's definitely not a two-parter. Thank you all. I guess my question is, I find, it's really quite tough. So the question is around, like, how do we find the right scale when it comes to actually trying to mobilize cohesively in a way that simultaneously sort of, utilizes all the hearts that we have in all the different places, right? Because obviously, like Elle Jones and Masuma are doing amazing work out in Mi'kma'ki, and there's like amazing work happening in like Cree lands in the prairies, Harsha Walia, and like all sorts of stuff happening in different pockets. But I'm sort of like curious if any of you have some ideas aside from this fabulous convening here, like how do we share our best and worst practices in a way that is both expansive, but also like contracts when it needs to contract? Make of that what you will. Thank you.
That's a good question. It's the endless question, particularly on the left, like how do we effectively organize the left, especially against the populist right? And I think that we've somewhat just cede that ground. It's like with Trump, where people just kind of like, he's just going to say what he wants, we can't stop, and I feel like we always have this sense of helplessness in the face of the growing right, that there's, nothing we can do. And I think we have to be building effective coalitions to intervene. I think I don't like when people say, oh, like, look how, like with the occupation of Ottawa, when it was kind of like, well, the right can organize and the left can. I'm like, well, we're not allowed to do those things. Like, we can't drive trucks into the middle of Ottawa. Like, it wouldn't happen. It's not like we're not organized. We're obviously not conservative white men, so we don't organize in the same conditions. So we always are organizing, but I think your question is, it's the endless point. Like, how do we move out of our silos? How do we organize cross-regionally in a country like Canada? How do we organize across movements effectively? And particularly, how do we do that in ways that effectively confront, particularly this threat of populism, which is in this moment capitalizing quite literally upon very real social harms that are going on, the inflation, the lack of access to food, the lack of housing, the very real economic constraints people are feeling. And we know that that often does push people towards this particular right wing. So I don't have a good answer other than we have to keep trying. We have to keep talking. We have to get in person with each other. We have to, make sure we're organizing using the instruments that we have, whether that's unions and pushing unions to do better on that, really pushing workers, for example, to understand what we're talking about with things like Islamophobia and anti-Black racism, and particularly working on that piece. And between our communities, we need to be definitely doing more organizing through our struggles. So I think it's just like trying to be effective in all the ways we can. But I think neoliberalism always just wants us to believe there's nothing that we can do. The state wants us to believe there's a totality and we can't organize against it. So I think it's recognizing that we can, that we have many wins. Ken is talking about like losing in court all the time. You still have to go to court and at least try and get those decisions. And we just have to keep trying and keep pushing and keep
And he's still radicalizing all his students.
So you know what I mean? I think that we can't take one loss. We're not going to win everything today. We all know that. It's long-term organizing. So not mobilizing, but actual organizing, which is that long, slow work of speaking to each other, teaching each other, going door to door if we have to, showing up at each other's stuff, whatever it is that we have to do. That's not a good answer. It's just like, yes, I agree with you. We need to organize. But we can, is my piece of hope.
Thank you, Elle. Atiyar Yaver, any last thoughts?
Yeah, just to thank you all for organizing this. It's very, very, very thoughtful and an honor and privilege to be involved in this discussion.
Yes, thank you.
The honor and privilege was entirely ours to have you,
Definitely.
Yaver, Elle, Atia, Kent, Tim. Do you want to say something?
Yeah, sorry. Thanks so much, everybody. It was really an honor to have and a really great discussion. Thanks so much, Aziza, for your wonderful co-moderation skills and your insightful questions. It's really great to be working with you on this. And thanks to my colleague, Anne, who's done so much to make sure that tonight ran smoothly. We're going to be posting a recording of this, so we'll share the link with everybody, and hopefully you can share it further. It was great to have so many people out with us tonight, but for such a really a phenomenal discussion, and I don't think I could have asked for or we could have asked for 4 better people to talk about this. Hopefully we'll be able to share it a lot further, maybe spark some of those conversations and bring people together that can help push this this movement forward, and hopefully we'll be able to do it again together sometime. And yeah, thanks so much, everybody. Really appreciate it.
Yeah. Bye-bye.
Everybody.
Thank you.
Thank you, everyone.